custody of respondents so that you can finalize investigations. Your Honor, the investigation relates to offense of false publication, taking part in an unlawful assembly and creating disturbance contrary to the relevant sections of the law as captured in paragraph 2, page 1 of the application. Your Honor, the grounds are as follows. The respondents were arrested on the 25th of July this year at around 11:30. That's Nairobi Central Business District, together with others, alleged that they caused a lot of peace and inconvenience other road users by blocking the road, by placing one white coat and 7 white crosses inscribed on the streets. In the process, they were distributing t-shirts and black cards labeled with exciting words. Various social media platforms established the financiers of this alleged conduct. Your Honor, we wish to affidavit of Inspector George Karanja in its entirety. Your Honor, once the suspects were booked, they have not been able to provide their places to avoid. Your Honor, the mobile phones which were confiscated have not been subjected to forensic analysis, seeing that one of the offenses that they are alleged to have committed is under the Computer Misuse and Cybercrime Act. It is alleged, Your Honor, that if released, they might interfere with investigations, so that they will have the authority of getting into their social media accounts and destroying the evidence therein. Your Honor, for that case, the IO says since they have not established their places of abode, there are flashes. And if released before those investigations are completed, it may jeopardize the investigation of the court. Your Honor, I pray that the application be allowed as
is a matter of public interest. It protects the terms. There must be compelling results. I have listened to my sister from the prosecution and the application, but Your Honor, there are no compounding reasons from our side to suffice the application to hold our clients for 21 days. Reasons being that in their application they've alluded that they've already confiscated the mobile phones. Our clients, as law-abiding citizens, in this instance, complied with the police from the onset when they were arrested yesterday, taken to Kamkunji police station where
so
they
if you want to write what you're saying,
sorry.
unless you want to talk, then
And arraigned at Kamkunji police station where they slept the night. They complied with the authorities. What is enshrined in our 2010 Constitution, and they complied by issuing a notice to the authorities as stipulated by law. Phones were confiscated as stated by my sister in the prosecution for investigation. Therefore, it shows the compliance that notice that the fourth respondent is a law-abiding citizen. The events of the couple of weeks that preceded this arrest proved that he has and has throughout been in full respect of the rule of law. And the last time, Your Honor, he was brought. Yes, yes, and I'll explain why. Court. Your Honor, from the foregoing, it proves that our client and the fourth respondent, as well as the rest, Your Honor, the application to hold our clients for the next 21 days aboard, yet that is not true. They allege that they have the phones, which they claim it's because of the false publication. They wish to hold the phones for further investigation. Therefore, in our opinion, there is no compelling reasons as to why our clients should be held for 21 days, because if they are investigating on the false publication and everything, the matter is already in public domain. And number two, because they already have in custody the phones of the accused persons. The accused persons, therefore, are not at flight risk, and so there is no compelling reason whatsoever as to why they should not be allowed to be released on bail, by virtue that they have shown goodwill and have done what the prerequisite law requires of notifying the authorities of their peaceful protests. I would wish to invite my colleague Njeru Biden to continue. For your colleague, he was here on 19th of June. Yeah, I will give it to you, Your Honor.
And one of the possible charges is creating disturbance. The second compelling reason is the strength of the prosecution case. To avoid belaboring, to the extent that the character of any or all of the accused persons is questionable. Apologies, Your Honor. The respondents, not accused. Interference with witnesses, which will clearly be fishing on the part of the prosecution, because there are no witnesses. They are still conducting the investigations. And if there are any witnesses who can be interfered with, they have not presented the same to court, nor given any reasons or any evidence in support of any interference with any witness at all.
He will be brief on as guided.
Also for the respondent, I also wish to place my colleagues his test of it. Yes, yes. Versus Fifth. Yes. 2018.
In the application grounds, and that holding suspects in custody while investigations are ongoing is unconstitutional and amounts to unlawful detention. Number two, Your Honor, justice is a right and should be seen to be achieved. It is not a cloistered virtue. And we're also emphasizing on justice. We also bring on board the humanitarian grounds and human dignity. Fortunate that his brother met his unfortunate demise during this protest. And the funerals are ongoing, the preparations are ongoing. And if they insist on keeping him here 21 days, pray tell, are we trying to tell him that he should not go and attend his brother's funeral and mother? So his mother.
Just trying to clarify.
Apologies, Your Honor, on that.
Do you have counsel?
Apologies, Your Honor. He was just trying to emphasize on something.
Yes.
The mother is also supposed to be buried on, as per the receipts that we have here. If we detain him here for 21 days without recourse and course of justice, we also denied him a chance on humanitarian ground. I submit that the application fronted by the DPP is unconstitutional and should not even see the day of the day. Thank you. And I dedicate 1 more minute to Mr. Stephen Onjiru.
Okay, let's just take your time. So that you don't feel constrained.
What respondents arrest or detention previously. Your Honor, even if there was one, each case is unique and has its different set of circumstances, and so the court should disregard that point by the respondent's counsel. Your Honor, counsel has also submitted that the prosecution has no strong case. Your Honor, as earlier communicated, investigations are ongoing. Your Honor, the IO is yet to record all the witness statements and is in the process of gathering evidence. So in essence, the counsel is jumping the gun. Your Honor, the counsel has also indicated that there are no sufficient grounds before the respondents. Your Honor, as indicated in the application, our process, I wish to just highlight paragraph number 3, 4, 5, and 6 of the grounds in the application and submit that the IO has sufficient grounds to apply for the application of this case.
Yes, Your Honor. I will let Ms. Janja highlight on that case. She was the one on record on that matter. No, we didn't have a
Mr. Bonface was brought to this court without any charge, and the court just had us without any file being in place, and he was released.
No, the fourth.
The fourth respondent. Yes. Yes.
So we don't have a petition, but it was just a clear indication of miscarriage of justice. For pressure, the state had to make a directive to release him. Additionally, when the ODPP gave a directive that is not intended to prefer any charges.
So it was not?
It was never documented or moved.